In my view, the judge, in that very, very marathon judgment, has committed grave and substantial errors in large numbers. And I say so with the greatest of respect. First of all, the judge recognized and accepted our submissions that the case was not properly pleaded. The judge from the bench admitted or ruled that the pleadings presented and the case that was presented in the pleadings could not withstand the judicial scrutiny. Now that is a major issue. If a judge forms that view, that should be the end of the case. It's either that or we abolish the principles and rules of pleadings, because pleadings is that mechanism by which you present a case. The judge traveled all lengths to find justifiable reasons for continuing to hear the case. In fact, he built the pleadings. He supplied all the deficiencies in the pleadings so that he could come to a conclusion. So that's the first thing. Secondly, the judge failed to address the distinction which I've been making from the inception of this case between a right and a freedom. I began this case by saying that there is a right. Striking is a legitimate form of expression in our law. No one disputes that. It was once illegal, but it is now legal. But whether it has reached and has been elevated to a right as opposed to a freedom is where a distinction has to be drawn. Now, go to the Constitution yourself and you will see Article 147 that the judge spent 50 pages on. You will see it divides the things that they are speaking about into rights and freedoms. When it comes to strike, it speaks to a freedom to strike. The judge rightly went to the constitutional reform process and looked at the recommendations. And the recommendations was to constitutionalize a right to strike. But what did the drafter do? The drafter put it in the Constitution, but did not use the term strike, right. He used the term freedom. Now, the reason being that when you exercise a freedom by its very nature constitutes options. So you have options to do things. And why that is important? Because those options carry with them, when you exercise them, certain consequences. A consequence of exercising your right to freedom, which the Constitution gives you, is the corollary of not being paid for the exercise of that freedom. What the judge has found is that you have a right to strike, and in doing so he has misread the Constitution. He has equated the term freedom with right, but he has not addressed the other repercussions, because now you will have striking workers who are going to be compensated for work not done. What you have done here is that you have turned the law upside down, because the monies that you are going to be paid with for exercising this alleged right which you now have is the monies of the employer. The employer has money, means property in law. Money includes property. The employer has a right to protection of his property, and you can't deprive him of his property unless he gets some value for it. So here it is that you have a worker now who will not work but must be paid. So in satisfying one constitutional right, according to the judge, what he has in effect done, whether consciously or unconsciously, he has deprived and denied the constitutional right of another. That is why in the recommendation that came to the Constitutional Reform Committee for the enactment of that amendment, it says you must constitutionalize this strike with reasonable limitations. And that is why the word freedom was used, because that word freedom maintained the no right, no work, no pay principle. So that is gone. The judge has overreached. That is a matter for Parliament. You can't use the tool of interpretation to expand the meaning of words beyond their natural grammatical meaning. In fact, read into the Constitution a word that is not there. You can't convert the term freedom into a right using interpretative mechanisms and principles. That is completely wrong. And then you have the other principle about the deduction of union dues. Now the judge found, strangely and wrongly, that the government has not done so in relation to other unions. Now where did he get that evidence from? There is no evidence before the court that the government extends this facility to other unions. In fact, the only evidence on this matter that is before the court is the Nandlall case, in which the court, as you know, the government decided not to continue offering that service to public servants. So on the contrary, you had authority before the court which demonstrated and illustrated and established that the government did not extend, or in fact terminated, this service from another union. But there is absolutely no evidence of the converse, that the government is extending this to other unions. So he made that finding. Secondly, the voluntary service of the government to offer or to act as an agent for the collection of union dues is not grounded in law. It is not grounded in contract. The judge made a leap and situated it under the Constitution. He says that is an integral part of freedom to associate and freedom to be part of a trade union. By what stretch of the imagination would government voluntarily deciding to deduct union dues from workers' salary and paying it to a union, how does that affect your right to form a union? There are thousands and millions of unions in the world that collect their own union dues, and they are not suffering. The Public Service Union itself, since the Gopal decision, has been collecting its union dues. So on what basis you making a connection between the government offering this service, and if the government refuses to do so, it's going to affect your right to form a union and goes to the heart of trade unionism? I mean, these are quantum leaps that are not supported by anything. And then the judge rejects the concept of a legitimate expectation and says that this can be government policy. Well, what is it? It's not grounded in the Constitution. It's not grounded in contract. It's not grounded under any other obligation. So is it that the government for the rest of its life got to continue offering a gratuitous service? Once the government starts to do something, or you start to do something, you could never stop? I mean, these are vacuous conclusions. And that is why the decision has to be appealed. And there's another component of the decision that I find objectionable, and I say so with the greatest of respect. It is the language that was used by the judge. You know, judges are required to use temperate language. A judicial officer must conduct himself in a particular way. Judges rule against governments and against parties every day. But you have to use temperate language, and you have to understand that nobody can stand up and object to you when you're reading a judgment, and your judgment becomes part of the permanent record. You would have listened, or if you didn't, look back at the judgment, and you would get the clear impression that there was a almost an intent, deeply driven intent to use very, very strong language that I believe could have been avoided. And then look at the commentary made about public officers. Now, if you disbelieve a witness, judges disbelieve witnesses every day. That's not a that's not an unusual thing, but you don't subject witnesses to these type of scathing attacks. So this case has a lot of unusual things in it. I will obviously have to speak more on it because it requires a thorough examination. We don't have the judgment as you're aware, but I'm just speaking based upon what I have heard. And the government certainly will have to appeal it and will have to seek a stay of execution in respect of the orders granted. Now, the case now has gone way beyond this teacher's matter. It's gone way beyond that. It has tremendous and wide-ranging implications for industrial relations in this country, and that's what I said from the beginning. If the judge rules against the position that we are advocating, the judge is putting Guyana in a place where no other country in this hemisphere has gone, and that is where he has taken us. So workers can apparently strike with impunity. And it would appear as though every worker, every strike that is called, the court has to determine whether the strike is reasonable. Because that's what the judge says. If the strike is reasonable, then you got to pay. So every strike now will have to reach the court system, because I don't know, the workers are going to say that they are reasonable, the employer will say that they are reasonable. So every strike now will have to end up in the court. For public policy reasons, this decision must be reviewed, because it is it is unique from so many perspectives and on so many bases. Any question you want to ask?